Greetings of the day. I am Shreya Arora, a fourth year law student from Vivekananda Institute of Professional Studies. I've developed a keen interest in intellectual property rights legal, hence decided to apply for this internship. I had a very good experience with FICCI. What I believe is a good internship depends on three things: your mentor, your co interns, and the quality of work you are assigned. And luckily, I got all three of them here. Having a mentor like Divyesh sir, it all felt so easy. No communication barriers, no hesitation, nothing. And best of all, any suggestion given by any intern matters. That's something we don't see everywhere. I would love to work again with Vicky someday and hopefully get to meet the team behind all the hard work done. So, yeah, the issue that I am willing to address in this presentation is cyber laws and the evolving IP issues. Hope you find it interesting. So, the concept of intellectual property rights refers to the creation of human minds, that is, copyright, patent, trademark, designs. But the Information Technology Act 2000 does not mention any concept related to infringement of IPR in the world of cyberspace. It shows that there is a growing need to adopt technological measures in protecting the rights of intellectual property owners. New intellectual property problem has been increased such as cyber squatting, trademark infringement, etc. Cybersquatting is a major concern related to IP issues, which involve the use of a domain name by a person with neither registration nor any inherent rights to the name. So, as we know, that intellectual property is one of the valuable assets of any person. For this purpose, there is a need for strict laws in the field of cyber laws so that crimes related to IPR could be avoided in future. Some measures can be suggested as the Information Technology Act is lacking somewhere in defining the jurisdiction issues, scope, cyber crimes related to IPR, and the Indian Trademark Act 1999 and Copyright Act 1957 are also silent on issues arising out of online trademark and copyright infringement. So basically, the internet is a global matrix of interconnected computer networks using the internet protocol to communicate with each other. Nothing embodies our electronic transformation more than this evolving medium. It has affected the way we live and the way we transact with others. India is signatory to the model law and is under an obligation to revise its laws as per the said model law. With the urgent need to bring suitable amendments in the existing laws to facilitate electronic governance, and the Information and Technology Act 2000 was passed. E-commerce nowadays has become very popular, especially in the corporate sector. So the advantages and scope of publicity of business through e-commerce or business on the World Wide Web can reach the surface very fast in any part of the world. But this has paved the way for the emergence of cybercrimes. Cybercrimes is where a computer is used as a means of committing crime or as a target of crime. Advancement of information technology and computers has created a new world in the cyberspace, giving rise to various legal issues which are still in doubt, that is, intellectual property issues. But IT Act 2000 lacks somewhere to deal with the matter of intellectual property. IT Act IT Act does not deal with the cyber squatting, that is, stealing of domain names from its legal owner, controlling the conduct of cyber cafes, like of lack of enforceability of the provisions relating to e-governance, jurisdiction in the cyberspace, cyber squatting, credit card frauds, cyber defamation, etc. So, the main objectives of the Information Technology Act 2000 are: First, to respond and to give effect to the United Nations and to all states to give favorable consideration to model law when they enact or revise their laws so as to facilitate harmonization of the laws governing alternatives to paper-based methods of communication and storage of information. Second, to provide legal recognition to transactions carried out by means of electronic data interchange and other means of electronic communication, commonly called as e-commerce, that involves the use of alternatives to paper-based methods of communication and storage of information. And the third, to facilitate e-filing of documents with the government agencies so as to promote efficient delivery of government service by means of reliable electronic records. So copyright in the digital medium. Basically, technology is a double edged sword. On the one hand, it is creating new means to fix the original expression in a tangible form, and on the other hand, it is being exploited in infringing the copyrights with impunity. Even some of the internet activities like caching, browsing, mirroring, scanning, downloading, uploading, or file swapping are an anathema to a purist. The question is whether such activities really infringe the five exclusive statutory rights of a copyright owner, such as first, to fix or store the information in a tangible form, second, to reproduce the copyrighted work, third, to sell, rent, lease, or otherwise distribute copies of the copyright work to the public. Fourth, to perform and display publicly the copyrighted work. And fifth, to prepare derivative works based on the copyright work. The answer is yes. Internet activities like caching, browsing, mirroring, scanning, etc., may result in first transmission of information from one computer system or network to another, involving temporary storage of that information. Second, an unauthorized storage of such information is a violation of the copyright owner's exclusive right to make copies, that is, to reproduce the copyrighted work. Third, a violation to the copyright owner's exclusive distribution right. An appearance of a copyright image in the web browser infringing the copyright owner's public display right. Fifth, an infringement of the copyright owner's exclusive right to prepare derivative works. That is, prima facie, the nature and characteristics of internet activities, which is such that there will certainly be infringements to the exclusive statutory rights of a copyright owner. So, what is the scope of trademarks in the online medium? Internet and the World Wide Web represent the online medium. It is natural that a business entity claiming ownership of certain trademarks would like to extend its monopoly to this new medium as well. But the monopoly rights of trademark owners to own, license, sell, exhibit, market, or promote are being threatened by web based technology tools like search engines, meta tags, and hyperlinks. Meta tagging raises several trademark issues, including is it trademark infringement or passing off to embed another's trademark in HTML tags on one's web page? What about repeating another's trademark as buried code or invisible text on one's web page? Is it unlawful for a search engine or directory to sell premium placements for banner ads keyed to another's trademark? How about the sale of an enhanced relevancy ranking for searches keyed to another's trademark? And what about liability of search engines in providing a cached copy of the web page viewed on the day it was indexed, when the original was no longer available on the official website? Overture or Google might suggest to an advertiser who pays to use the term sports shoes to also add Nike, Adidas, or Bata to their search terms to help them get more visibility. So, when a request for Nike running shoes is keyed in, the advertiser, who could be retailer, a rival shoemaker, or a sale discounter, would automatically get the top billing in the search results. Hence, the search engines have to exercise caution in selling third party ads that link to search terms with trademark owners, example Nike, name alone, or in variations of phrases. In view of these possible trademark infringements, Google has recently introduced its trademark policy. It has agreed to sorry, remove ads in a trademark owner goes through Google's formal trademark complaint procedures. In Niton Corporation versus Radiation Monitoring Devices, an infringement action was brought in against the radiation monitoring devices for directly copying Niton's meta tags, and HTML code. The result, an internet search using the phrase homepage of Niton Corporation, revealed three matches for Niton's website and five for RMD's website. The court granted injunction against RMD. So, domain names as digital marks in the online medium. In the last 10 years, domain names have become a kind of e-commerce marks in the online medium. These are digital business addresses, a point of business contact or transaction. Functionally speaking, domain names provide a system of easy to remember internet addresses, which can be translated by the domain name system into the numeric addresses, which are internet protocols numbers, that is IP numbers, used by the network. It is important to know that there is no legal definition of what a name is. The domain name consists of different parts. The first part is known as second level domain or subdomain, and is the part that can be chosen by the person registering the name. The end part, which reflects standard term throughout the world, is known as top level domain or domain extension. These are commonly referred to as GTLDs, that is generic or global top level domains. Earlier, there were only 7 GTLDs, that is, for example, .com, .edu, or .gov, etc. 7 more GTLDs have recently been introduced, like .museum, .name, .pro, etc. Cyber squatter or typo squatter, sand, other trademark infringers have made the web a legal minefield. The question that have folks the courts for many years now is: is domain name a property? If yes, to whom does the property belong? Is a domain name property of the first person that registers it, or is it the property of the trademark owner that has invested time and money developing goodwill and reputation associated with the mark? A cyber squatter is an internet user who has registered multiple domain names with the hope of selling them to the business who own trademarks identical to those names. Another variant is typo squatter, who seeks to profit from controlling domain names, but instead of acquiring a domain name identical to the registered trademark owner, the typo squatter obtains common typographical permutations of domain names surrounding a high traffic site. In a case of Yahoo Inc. versus Akash Arora, the defendant was restrained from using the domain name yahooindia.com, which had the format, content, and color scheme identical to the plaintiff's yahoo.com. It was observed by Mr. M.K. Sharma, judge of the Delhi High Court, that if an individual is a sophisticated user of the internet, he may be an unsophisticated consumer of information, and such a person may find out his or her way to the different internet site which provides almost similar type of information as that of the plaintiff, and thereby confusion could be created in the mind of the said person who intends to visit the internet site of the plaintiff but in fact reaches the internet site of the defendant. It was held that although the word services may not find place in the expression used in the section 27 and 29 of the Act, services rendered have to be recognized for an action of passing off. That is, the two marks or domain names, Yahoo of the plaintiff and Yahoo India of the defendant, are almost similar, expecting for the use of suffix India in the latter. It is significant to note that the concept of trademark is closely related to commerce, whether offline or online. In both the places, its basic premise has remained the same, that is, to protect the public so that it may be confident that in purchasing a product bearing a particular trademark which is favorably known, it will get the product which it asks for and wants to get, and secondly where the owner of the trademark has spent energy, time and money in presenting to the public the product. He is protected in his investment from its misappropriation by trademark infringers, including cyber squatter. It can be concluded that there is no provision related to Trademark and Copyright Act in India under the IT Act. Also, it lacks somewhere in respect of jurisdiction issues, cyber crimes related to IPR, cyber stalking, cyber defamation, etc. Intellectual property is one of the valuable and important assets of any person because a person puts his skill and labor for creation of intellectual property. So there is a need for stricter laws in this field so that crime related to IPR could be avoided in future. Thank you. That's all.